great to see some of your faces and a whole lot of names that we recognize. I hope everybody is doing well, still dealing with the COVID situation. So I hope your families and you are figuring everything out. And those of you working in the office, I hope that's going well for you. We have just a couple of announcements for NALS. We have 2 lunch and learns that are scheduled in the near future. July 22nd with Lucas Elliott of Frost Brown Todd, and we have August 12th with Kelly Knowles of Bass Berry Sims. So the July 22nd is referenced in the July edition of The Verdict. And in the August edition, Kelly Knowles, her lunch and learn will be referenced and information will be provided. As always, we'll be giving out CLE credit certificates for today's lunch and learn. So if you want that, make sure to email me and request a copy, and I will send that to you via email. If anybody has any questions, just send me an email as well, or Amy, or put it in the chat box. So today I'd like to introduce our guest speaker. His name is Gary Rubenstein. He is an attorney practicing law with Schulman, LeRoy, and Bennett. He's going to focus on landlord tenant matters. He's going to go over the CARES Act and how that affects the work that he does. His clients include management companies in the Nashville area. So if you will please welcome Mr. Rubenstein, Gary. I'll let him go ahead and take over. Oh, and one other thing. So question and answers, we're going to do them like we have been. You can either raise your hand, and Amy and I, if you're on video, or you can put your question in the chat box, which is located at the bottom. The chat feature is located at the bottom of your screen. Again, let's welcome Gary. Thank you so much.
Thank you. Hi, everybody. Okay, we're going to talk a little landlord tenant law today. And so I think we should start off with where we are with the courts. Number 1, pursuant to an order by the presiding judge of General Sessions Court, Judge Linda Jones, there is no landlord-tenant hearings for the month of July. This was based on Nashville going from phase 3 back to phase 2. So last Thursday, Judge Jones ordered that there be no landlord-tenant cases heard. And of course, that's through July. I would think, depending upon what happens with the amount of cases between now and the end of July, certainly wouldn't surprise me if it was extended. And at this point, it's just every day you look at your inbox, see if there are any orders coming down from the Supreme Court or the local judges. Now, this suspension of court proceedings, as of today, it is only for Davidson County. As far as I know, any of the surrounding counties are still holding court, open court, pursuant to whatever limitations they have. And I found that it just changes from county to county. Sumner County limited the number of people coming into the courtroom. Wilson County limited the number of people coming into the courtroom. Clarksville, Montgomery County let everybody in with no social distancing. So it's just, yeah, I know. And the thing that made it even worse in Clarksville was because they haven't had court for so long, they had one of the longest dockets they ever had. So they had people in the courtroom, they had people in the corridors, and anyway. So if you guys do work in other than Davidson County, you need to check that specific county to see what their rules are. It does appear that I think every place, but maybe Clarksville, they required you to have a mask. And it certainly, I think they probably changed it in Clarksville too, where you have to have a mask. So anyhow, Davidson County, no landlord tenant cases for this month. We'll just have to wait and see if they're back and running in August. So as long as we're talking basically about how COVID affects this, we can talk a little bit about the CARES Act. And the CARES Act is federal legislation. It covers a whole variety of topics. But I'm going to focus on the 1.5 pages that relates to landlord tenant. And basically what happened was that on March 27th, that was the date that this law took effect. So there is a 120-day moratorium on evictions for what are called covered properties, okay? So it's 120 days from March 27th, which puts us somewhere, I think it's about like July 25th. And the first thing, if you're doing that type of work, that needs to be checked is whether the property that you're representing is what is known as a covered property. A covered property is a property that has a federally backed mortgage. Now, the most common are Freddie Mac and Fannie Mae, but of course there are certainly a myriad of other federal programs. So if you represent a landlord and you want to institute some type of legal action, if you want to institute an eviction, you need to check to see if you are a covered property or not. I've found percentage-wise that well over half of my clients are covered properties. So therefore, I haven't been doing anything for the last 3.5 months except, eating lunch. But anyway, you need to check that and see if it's a covered property. If it is, then you don't really do anything for 120 days from March 27th, which, as I said, will put you about July 25th. Now, what happens July 25th? Well, July 25th, you don't automatically go back to filing evictions. On July 25th or 6th, whatever after the 120 days, then the landlord needs to send a notice to vacate to these delinquent tenants, needs to give them a 30-day written notice. So the actual filing of detainer warrants for your garden variety apartment complex, let's say, that has a federally backed mortgage, they're not going to be filed until the end of August, assuming your clients are on the ball and they have these notices ready to go and they send them on or about July 25th, then the end of August, they'll actually be able to file the eviction. Now, there are, an exception. These are for cases for non-payment of rent, which are the majority of cases filed. What about if there is a situation where you want to evict somebody for possession for some bad acts? You can proceed with that under the CARES Act, but you may not be able to go to court if your court is closed, as in Davidson County being closed this month. So the CARES Act does not apply to, bad acts or evictions for those type of things. But again, whether the courts will be open or not, that'll be another story. And so that's basically how the CARES Act, affects landlord tenant. And to the greatest extent, again, it put a stop to well over half of that type of activity because, again, most of your apartments do have mortgages and most of those are federally backed. You may find some sort of mom and pop type of landlords that don't have federally backed mortgages. And of course, they would not be part and covered by the CARES Act. Now, when you do file an eviction, you have to file with it what is called a declaration. And this is something new. This is a new part of your detainer warrant pleading. It's called a declaration. Basically, you're checking off boxes, but in that, you're basically telling the court whether or not you're a covered property or not, whether or not this is a rent situation or not. And obviously, depending upon the answers, you may or may not be able to go forward. But what is important is that, and this came from the Tennessee Supreme Court, the judge will not allow a judgment to be entered unless this declaration has been on file for at least 10 days. So if you filed a case and you don't have the declaration and you go to court, assuming there is court, and you go to court, then you'll have to continue the case generally for a couple weeks so you get the declaration filed. Now, the problem I had this week is we had a couple of cases that we filed way back when, before this declaration came down, and I had court what would have been 2 weeks ago. So I filed the declarations, then the cases got continued 2 weeks to this week, but then I couldn't go to court for them. And so it didn't matter that you actually started this process. And again, there may be some cases out there that were started before the CARES Act took effect, that is, were filed in the early part of March. Those are allowed to continue. You can continue and complete if you had a filing before March 27th. Now, at this point in time, I don't know how many of those are left. Probably most of those have been resolved either by payment or judgment or whatever have you. But that is where we currently are as far as how the CARES Act affects landlord tenant, how Tennessee Supreme Court orders affect us, and how the presiding judge of Davidson County affects us.
I have a question just to follow that up.
Mm-hmm.
So with the courts being not in session because of COVID, so it's just pending indefinitely?
It is up to the plaintiff to reset it. In other words, the day that I go to court in Nashville was yesterday. So I had several cases set yesterday, and of course there was no court yesterday. So during this interim period, a lot of times these things resolve. The person pays the rent, the person vacates, come to some agreement. So today I've had to go through the cases that I had set for yesterday to determine if my client still needs to go forward with it. And assuming the answer is yes, then the next step is for me to send a notice to the court, obviously copying the tenant, saying that this case was set on July, blah, blah. We didn't have court that day, therefore I request that it be reset for Tuesday, August 4th, 2020. So I'm cranking those letters out today on those cases that still need to be kept or put back on the docket. Yeah, there's a question about this form. Yeah, almost all clerk's offices have this form that you can get. It's, just two sides of a piece of paper. I mean, and if there's somebody out there that wants a copy of one, just send me an email or something afterwards. I'll have my assistant send you one. But it's, there's at the top of it, it's just like filling out a detainer warrant. It's just another piece of paper to be attached. You have the style of the case, you have the person that's answering the questions. Like I say, you have 4 fill in the blank questions. and then you sign it on the reverse side. And what's good about the form is, in case there's a question about whether the mortgage is federally backed or not, they're listed there. As I said, most of them are Freddie Mac or Fannie Mae, but they also have other ones. Does the CARES Act apply to individual homeowners? I would say yes. Now, the thing with individual homeowners is they may not have one of these federally backed mortgages. So a lot of my sort of mom and pop clients I have, we're able to go ahead because they don't have a federally backed mortgage. But as I look at the statute, the federal statute, it did not make any exceptions for whether or not, it was a homeowner or whatever. That's a good question, though. All right. So, assuming we don't have any more questions about the CARES Act, about the Supreme Court order, about the General Sessions order, we'll go back and talk about regular landlord-tenant law and what we need to do. Basically, a lease is just a contract. It's just like contract, like any other contracts that you work with on a daily basis. And a contract, as we know, is just an enforceable promise. And so that's all a lease contract is, or rental agreement. It's just a contract. Now, I have most of my practice is residential, but I will say this about commercial, in that commercial landlord tenant is pretty much straight contract interpretation. In other words, we're going to talk about Tennessee's Uniform Residential Landlord and Tenant Act in a minute, but there is no Tennessee Uniform Commercial Landlord and Tenant. And I think the reason for that is, as opposed to residential, where there's a real disparity in bargaining power. I mean, most of the time the landlord presents a lease as a take it or leave it type situation. Tenants have more bargaining power in a commercial situation. And in fact, some commercial tenants actually have more bargaining power than the landlord. I mean, in the past, I've worked with leases involving Walmart, for example. Well, Walmart had greater bargaining power than my client did because they're Walmart, okay? And so instead of, the situation was really reversed in that Walmart presented its commercial lease basically as a take it or leave it. And then my client, the commercial landlord, didn't really have a lot of bargaining power to adjust terms and what have you. So again, when you're dealing with commercial, it's pretty much contract interpretation. As far as litigation is involved, in any 1 year, you might have a couple of reported cases dealing with landlord-tenant, either commercial or residential, but not a whole lot. Usually, the ones that you do see deal with some type of housing where there's, federal government involved, where if a tenant wants to dispute an eviction, they're able to access some type of legal aid. And of course, legal aid, having the time and money to do so, they can afford to take cases to the Court of Appeals, and if necessary, the Supreme Court, where the ordinary run-of-the-mill tenant's not going to do that. So let's go over and talk a little bit about the Landlord and Tenant Act. It is been a law here in Tennessee since the middle 70s, I think about 75. And initially it was only applicable to the 4 largest counties by population: Davidson, Shelby, Hamilton, and Knox. And there actually was some litigations because some counties wanted to opt in, some counties didn't want to be in. So eventually it's based on population. So if the county has enough people in it, they're in the Landlord and Tenant Act. And even if, I found that even if you are in a county that doesn't have enough people to be in the Landlord Tenant Act, a lot of times the judge will go by that anyway. It is very persuasive authority. So here in Middle Tennessee, I think just about all your counties here have enough people. I mean, you can check the grid in the statute, but I'm thinking about the only county around here that may not have enough people would probably be Cheatham. I don't know that Cheatham has enough. Of course, they don't have a lot of multifamily housing, so I don't do much work in Cheatham, but I would think that Cheatham might not have enough people, but just about all the other counties that surround Davidson probably do. Or again, as I said, even if they don't, the judges there probably go by that. So the most important things, let's see, what does the judge go by in Cheatham, assuming it doesn't have the requirement? Well, goes by the good old common law, basically. And there is besides the common law, there is a statute, it's very brief, that does apply to non-landlord tenant counties. It is, the Landlord Tenant Act that we go by is 6628-101. If you're in Cheatham County, you may want to look at 66-7-101 at SEC, because there are a couple of differences as far as notices and when you can go to court. But as I said, 66-7-101, there's probably about 4 or 5 sections in that, when in the Landlord Tenant Act, there's, it's a very comprehensive statute. So again, if you're in Cheatham County, the judge would look at 66-7-101 at SEC, and may well also look at the Landlord Tenant Act. And then failing that, we'll look at the common law. And then failing that, as most judges do in the country, they'll just decide if something ain't right or not. That's what I found. Okay, so if we look under the Landlord Tenant Act, there are 2 types of notices that are important. And these are notices relating to behavior. Under the Landlord Tenant Act, we have what is called the 14-day cure letter. And this is a notice that is sent by the landlord to the tenant for what I call garden variety breaches of the lease, of behavior, such as loud noise, such as an unauthorized guest who's become a permanent occupant, such as parking in a restricted area, those type of things. What I call run-of-the-mill violations of the lease or the rules and regulations. So what will happen is the landlord or the attorney will send a letter to this tenant and will outline what the problem is. Dear Ms. Hughes, please be advised that I represent ABC Apartments, Inc. It's come to the attention of management that you have allowed an unauthorized guest to become a permanent occupant in your apartment. This person must vacate the premises. So under the statute with the 14-day cure, basically the tenant has 14 days to cure the problem. If the unauthorized guest vacates, then the lease continues as if nothing had happened. Nothing is filed with court. You just have a copy of this letter in the file. Everybody goes along, has a good time. Now, for example, what if you send a 14-day cure letter because you have Cujo the pit bull. So you write the letter to the tenant, "Dear Ms. Hughes, it's come to the attention that you are harboring Cujo the pit bull. Your lease and rules and regulations provide that this is a breed of canine that's not allowed here. Therefore, you must remove this animal. Thank you for your cooperation. Sincerely yours, landlord." Okay, so the tenant gets this letter and sends Cujo into the country for a while, and everything's good. So the lease rocks along. Well, what happens if 3 months down the road, Cujo returns? Okay, the second part of that notice statute says that if the same act or omission that constituted a prior noncompliance recurs within 6 months, then the landlord can terminate the lease with at least a 7-day written notice. 7-day written notice. Again, do landlords always terminate the lease? No. Sometimes they just send a second letter that says, "Hey, Cujo's back, get rid of Cujo for good, blah, blah, blah." Okay, that's what the landlord wants to do. But again, if the same act or omission recurs within 6 months, then again, the landlord can terminate the lease. That's what the landlord wants to do. One question that I'm asked quite a bit is, how do you send this notice? How do you send this notice? Well, generally speaking, of the 14-day notice, I generally just send it regular mail. Sometimes my clients will say, send it regular mail and certified mail. And it's like, okay, that's your dime if you want to do that. But generally, I don't find that it's of supreme importance to send it certified mail. Now, one other thing that can be used, and this was, I won't say a recent addition, it's probably been on the books now for a few years, but something that your clients should know about is notices can be sent via email. If the resident provides an email when they enter into the rental agreement, then you can send any notices, and it isn't just when they're violating the lease, but notices can be sent via email. The only catch to this is a landlord cannot require an email address as a condition of renting the premises. So if a person's got a lot of money, otherwise qualifies, but doesn't want to provide the email address, you can't require it. But as I'm sure that you've learned in other areas of the law, when you're given notice of something, it's always better to give more than not enough. So again, besides mailing the 14-day cure letter, do some of my clients email that to the tenant? Yes. Do some of my clients get the copy that I sent to them and tack it on their door? Some do. I really don't advise doing that because while I'm not sure that the tenant has a privacy right, if you will, it does tend to upset the tenant. So as a general rule, I don't advise actually posting that letter on the door, assuming there's other ways of communicating it. So that's the 14-day cure. The other type of notice in the Landlord Tenant Act is what's called the 3-day notice to vacate. Now, the 3-day notice to vacate is obviously for much more serious violations and situations. Generally, we're talking about violence, significant property damage, drugs, and it can also be for housekeeping if housekeeping is so bad in the unit as to constitute a health hazard. Okay, so if you have these situations where you have violent or threatening behavior or an arrest for drugs or something like that, then you can send the 3-day notice to vacate. Now, as opposed to the 14-day, with the 3-day, you don't have the opportunity to cure. The tenant does not have the opportunity to cure. In other words, the tenant just has to vacate. Again, like anything else, there can be negotiation involved, and perhaps the landlord decides not to enforce it and proceed with that. But again, just remember that any of these decisions made on whether or not the person can stay or not, they have to be made on the basis of non-discriminatory factors. So you have the 3-day notice to vacate, and because this is so important, then I do send it both regular mail and certified mail. Does it have to be personally served? No, they just have to receive it. And so again, to make sure they receive it, again, because it's so important, I always advise sending it, regular mail and certified mail. Now, one other difference is because you're terminating the lease, the landlord has a greater responsibility. And that is, if an eviction is pursuant to a 3-day notice to vacate, and it's deemed not in good faith, then the tenant actually has a cause of action against the landlord. So again, you have to be more careful with the 3 days. Of course, number one, never ever accuse the tenant of a crime, okay? Do not say, we're giving you this 3-day notice to vacate because you're a no good drug dealer, okay? If the charges wind up getting dismissed, you might find yourself on the other side of a lawsuit. So again, what do you say? Say, this 3-day is being sent to you because of an incident that occurred on July 6, 2020 at 4:30 p.m. At that time, it was necessary for the Metropolitan Police Department to investigate this situation. Their file remains open and the investigation is ongoing. And because of the behavior exhibited at that time, management has determined that your lease should be terminated. But you don't say, we're kicking you out because you're a no good drug dealer, okay? Because in case it turns out the person isn't, then you may be looking at the other side of a lawsuit. Now, again, I think we could probably all agree that, yes, ma'am. Is that just a wave, or you flipping me off? That's not nice. Oh, okay, just a general wave. Everybody be calm, okay. Oh, she's saying something. Do you want to unmute Sheila? Unless she's yelling at me. If she's yelling at me, keep her muted. Go ahead, Sheila. I can't hear you. Do I need to do something? No? I'm sorry, I can't hear you, Sheila. There's something I need to do. Now I can.
Is that better?
Yes,
Okay.
ma'am.
When someone comes in and we go to tenant and they've actually a crime is committed, do you have to actually wait till they've been convicted or just when they've been arrested?
My opinion is you do not need to wait until they've been convicted. I mean, the eviction is civil, so you're not going to be required to prove your case beyond a reasonable doubt as is needed to be proven in a criminal case. So the short answer is no. And quite frankly, if you have it, I don't think it's even legally required that there be an arrest. In other words, if A beats up B, but for whatever reason, B, instead of calling the police, goes to the manager and says, A just beat me up at the pool for no reason, you can still send the 3-day. Obviously, it becomes a question of proof. If A says, not me, didn't do it, you still, the burden is on the landlord, to prove that. And generally speaking, though, if there is an arrest, there is almost never any opposition by the tenant to vacating. Generally, it's just a question of time. In other words, you have a situation like that, I'll get a call from the resident who received the 3-day notice, and they'll say, look, I know I got to leave, or I'm willing to leave. I just can't be out in 3 days. So then my question is, okay, I mean, quite frankly, it's reasonable. So I say, tell me, when can you be out? And they'll say, well, I can be out in a week or next weekend. Well, quite frankly, that sounds reasonable to me. And as long as I get some confirmation that that person says, this is when I'll be out and it's a reasonable amount of time, then that's fine. And the reason you want some sort of documentation is if the person doesn't leave on that date, then the mere fact that they've agreed to leave on that date, I mean, that's going to prove your case for you, even if the actual facts that gave rise to the 3-day notice are in dispute. The fact is, person goes into the landlord and says, here's my notice to vacate as of July 15th. You say, okay, well, he doesn't leave July 15th. You can file the eviction on him July 16th. Again, even just on the basis that he signed something that said he would move on the 15th. So I know it's probably a longer answer, but you don't have to wait for the conviction. You don't need to even have an arrest. But I found that in those situations where there is an arrest, generally speaking, the tenant is not going to dispute the right to possession. It's just generally a situation where they're talking about how much time, okay? So those are the two types of letters that are contained in the landlord tenant. That does not prevent your clients from sending their own letters, whether they be form letters or whatever. And a lot of times they'll send a letter before they will retain an attorney to send the 14-day. And again, do I have some of my clients that send their own 14-day letters? Yes, I do. And of course, all they need to be told is one time when I said, this won't pass muster, then again, they start having me send them. Again, you send a 14-day letter to somebody and you say, you have an unauthorized guest who has become a permanent resident. The resident goes in, talks to the manager, turns out it's a mistake. It's really the resident across the hall. Okay. Take the 14-day letter, you can put that in the circular file. That's sort of no harm, no foul there. But again, you certainly have to pay more attention on the 3-day notices to vacate, and if it's necessary to file suit to enforce the 3-day, you need to make sure that you have your ducks in a row. Okay, we got a question here. Can you also talk about the ADA? Oh yeah, the ADA, yeah, that keeps me in business. All right, well, we'll switch over to the ADA. And basically, what you have is the landlord is responsible for common areas, ingress, and egress. So again, if a tenant has a disability, they have to be able to get to the management office. They have to be able to get to the laundry room. They have to be able to have a parking spot. All of those things are the responsibility of the landlord. Now, what if you have a tenant that needs a modification of their apartment because of their disability? Generally speaking, they are entitled to have that accommodation made, the modification of their unit made. but it is at their expense. It is at their expense. And it can be their expense to move things up or down or this and that, and also their expense to put it back the way it was when they vacate, if that is how, if that's how the landlord wants it. Sometimes they just, would like to keep it. Most apartment complexes of any size do have ADA units. That is, units that already are prepared for people with disabilities. Now, I guess the first thing to know about the disabilities is the landlord doesn't ask about them, okay? If you're in the management office and a person comes in with a seeing eye dog, you don't ask that person if they're blind, okay? And you don't ask them because of their condition what they need. They tell you and then you respond to that, okay? So it's their responsibility to request either the accommodation or the modification. What's another example? Suppose I want to lease an apartment and my source of income is disability payments that I get on the 15th of every month. It's automatically deposited into my account on the 15th. And so the question is, most leases say rent's due on the 1st, late after the 5th, after which time a 10% late charge is assessed, which, by the way, is the maximum late charge in Tennessee under the Landlord Tenant Act is 10%. So the person says, hey, I get my money on the 15th. I want an accommodation. That is, I want my rent to be due on the 15th and considered late 5 days after that. Does the landlord have to do that? Yes, okay. Obviously they have to do that. So can you require, documentation if it's a disability that's not readily apparent? The answer is yes. You can require some documentation. You're not entitled to the person's medical records, like it was a personal injury case, okay? Generally speaking, a letter from a doctor that this person needs to have wider, longer, whatever it is, that's going to be sufficient. There was a question there where they said mental disability. Could you be a little more specific in what you mean by that? It means that a person that can't
Sure.
understand the lease?
So for anyone who claims that they are, let's say they get qualified for Social Security based on mental disabilities, and they're living in the property, and they are very much showcasing their mental disabilities, so much so that it disrupts other tenants. How does the ADA protect that tenant from being evicted when applying for that, the landlord knew this person is being accepted even knowing they have mental disabilities? So at what point does that act protect them? And the reason why is there are a lot of homeless people and there are a lot of other people who suffer from these mental disabilities, and it's almost a violation of their rights to just be evicted from place to place to place to place. There should be something there that protects their rights to be able to stay in longevity somewhere to a certain extent.
Well, generally, you would focus, I guess, on the actions that the person takes, and that I don't know that certain behavior becomes excusable if a person has a mental disability. Now, generally speaking, do I advise my landlord to try to be creative with regard to a solution that is if a person is, I don't know, Tourette syndrome, let's say, okay, and that bothers the neighbor, okay, well, before we say to that person that has Tourette syndrome, we're going to evict you, then generally I would talk to my client. I said, look, number one, you have to make sure that the neighbor's not being overly sensitive, because when you live in multifamily housing, you have to expect a certain amount of noise. But let's assume that the complaint is legitimate. Then the question is, can you move one or the other to a different unit or a different type of apartment? Or is there something you can put in, some sort of a buffer? Is there something you can do short of saying to that person with Tourette's, you got to go? And so I don't know if the ADA specifically speaks to that. And I'm not sure that they really have, a right, if you will, to have their behavior excused. But generally speaking, if, in our example, if this tenant with Tourette's is an otherwise good tenant, but that's the issue, then my question to the landlord before we go to eviction is, what can we do? Is there anything we can do? And if there is something that we can do, then obviously that's the best solution. Those attorneys with the Tennessee Fair Housing Council, I don't know if anybody there is familiar with them. They're good attorneys, and they're also good at coming up with possible solutions that, again, would protect the integrity of the lease premises for the landlord, but also, as you say, perhaps not make a person become homeless where, obviously they need quality housing like anybody else. Am I answering the question?
You are, and I have a second part to that question.
Okay.
So adversely, how does the ADA protect you from being sued against that tenant who claims you knew about my mental disabilities and now you're trying to put me out on the street?
Well, again, I don't know that it has been very often that an applicant to lease a property says, I want to lease these premises, but I have a mental disability. That does not happen very often, but I would assume that if it does, it would seem to me then the question from the management is, what can we do about it? Is this going to be something insurmountable where you shouldn't live in, say, multifamily housing, but in a detached type of home or whatever? So again, you bring up a good point in that this person who has this type of disability should bring it up initially so it can be dealt with at that time. And again, sometimes at the end of the day, you have to say, well, I'm sorry, but perhaps we can't accommodate you. And, a lot of management companies have different properties, and they might say, well, this property can't accommodate you, but we have this sister property here that maybe it's in a different side of town, but again, that might be more suitable. And again, the applicant may not get the exact apartment or premises they're looking for, but again, at least the manager is showing and making an effort in that regard. Got a third part?
No, thank you. I appreciate it. Well, the reason why I'm asking about that is because I have been studying about landlord tenant law, and
okay.
that realm has not been clear. So I wasn't sure, there's a side that protects the tenants, and then there's the side that protects the landlords, but neither side is very clear, and especially now how this CARES Act can protect those tenants from being pushed out on the street when so much is falling around them, if that makes any sense.
No, I agree with you, because generally speaking, most of the questions that I get relating to disability deal with somebody that has a mobility issue, a sight or hearing issue, or something like that, you know, some type of physical disability. And again, it's not often that you have someone. Now, the few that I have come in contact with is usually a person that has the mental disability. They will already have some type of caregiver, whether it's, you know, and again,
Someone
if
appointed.
exactly, and if the caregiver can get involved in the beginning with the landlord, then again, that's to say, look, this is what happens with this guy. And again, depending upon what it is that the landlord has to do to accommodate this person, then if the request is reasonable, then it's my opinion, the landlord has to do that, you know, has to do that. Any more questions? Okay, well, I got about 3 more minutes here. Wait a minute. What are the rights? Oh, entering the premises. Okay. Generally speaking, the landlord does not have a right just to enter the premises unless it's an emergency. If it's an emergency, you know, if there's a fire, if there's a flood, the landlord can go in without the permission of the tenant. Otherwise, generally not. And in fact, for example, you know, most apartment houses have periodic inspections, if you will. So what if you coming by, the landlord says, I need to change your air filter and we want to inspect the premises. And the tenant says, no, I'm not letting you in. Well, to me, something like that forms the basis for the 14-day cure letter, because most rental agreements provide for a cooperation clause. That is, the tenant has to cooperate with the landlord. So if the landlord says, hey, I need to come in, inspect the premises and change your air filters, and the tenant says, no, you're not coming in, then my opinion is you violated the cooperation clause and you're subject to getting the 14-day cure letter. And then if they don't cooperate further, then again, they would be subject to being evicted. But otherwise, landlord can only go in if it's an emergency. Any
Gary,
other questions?
I'm not sure if you saw the question just right above that from Tina Boone.
Okay.
It says, if the landlord doesn't allow them in because of their mental instability, can they be sued because of that? Or the thought that they have denied them because of their mental instability?
You know, if a person qualifies to lease the premises, then, you know, the landlord is going to be subject, I think, to liability for denial. Now, again, we're using the term mental disability, but I would think in that situation, what it actually is needs to be fleshed out some more in the beginning of the relationship. Now, of course, one of the issues is when the landlord asks for documentation, he's not allowed to get the medical records, if you will, of this person. As I said, like you do in a personal injury case, we can get all the medical records. You know, generally speaking, a landlord is only entitled to that sort of documentation and proof to determine if this person qualifies for the lease. So in the case of the mental disability, you know, I don't know that it would be enough for an applicant to say, yes, I got all this money. Yes, I can live on my own, but I'm letting you know I do have a mental disability. And it would just seem to me, and I don't think it's unreasonable for the landlord to say, well, what is it? Does it make you do things that otherwise wouldn't be acceptable? Are there going to be things we need to help you with that we wouldn't ordinarily need to help other tenants with? So I think by saying that, I do think the landlord is entitled to pursue a further investigation, and then depending upon what the response is, then again, the landlord still may be in a position where they need to lease it. What can the tenant do, and then I didn't see the rest of it. So the question was, what can the tenant do? What right does the tenant have when something has not been fixed and requested? Okay. Make sure, if you're representing the tenant, that they put whatever the problem is in writing. For example, if you don't have air conditioning in July, you don't have heat in February, and they don't fix it, the tenant needs to put that in writing. The landlord then has a reasonable amount of time to fix it. If the landlord doesn't fix it, then the tenant is entitled to either vacate the premises, or if, depending upon what it is, sometimes the tenant can actually hire a repair person, have the problem fixed, and deduct that amount from their rent for the next month. So if it says fix my air conditioner, they don't do it. Guy waits through the month of July. So July 25th, this guy's had enough of it. He spends $400 to get it fixed. Next month, his rent's $1,500 a month. He writes him a check for $1,100 and he attaches the receipt where he paid out $400. He can do that. The other thing he can do is continue to pay his rent as usual and sue for what's called diminution of fair rental value. I've never seen that done. All right. I think I'm about at the end of my time. This has been a lot of fun. And if anybody has any follow-up, I'm G. Rubenstein at slblawfirm.com. If you need copies of any of these forms or other questions, just let me know.
Hey, Gary, I did see one last question. Would you have time to answer that?
Yeah, it's okay with me. It's okay with everybody else.
All right, it's from Shelley. It says, what can the tenant do when the landlord entering the premises without notice?
Okay, again, that is addressed in the Landlord Tenant Act, and I suppose it depends on whether it's a one-time thing or, happens all the time. But the tenant would actually have a cause of action against the landlord for breach of what's called quiet enjoyment of the premises. So the tenant could actually sue. In fact, I had one. It was interesting. People were in the premises, and this contractor allegedly took some of the personal property of the tenant. Wasn't necessarily valuable property, but again, just sort of disturbed the premises. And again, while we may argue how much value a case like that has, I think that does constitute a cause of action. Okay.
That sounds great. Thank you, Gary, for answering all those questions and for the presentation. It was really, really interesting and applicable to a lot of us. If anybody wants a CLE certificate, please make sure to email me and I will send that to you. My email is in the chat box, and we recorded this this Lunch and Learn. We're going to post it to the NALS Facebook page and also the NALS YouTube channel. So if anybody needs that information, just let me or Amy know. And let's give Gary a round of either applause or just the spirit fingers right here. I got my son doing it. All right, y'all have a good Wednesday, and we'll see you on July 22nd for our next Lunch and Learn.
Thank you, Gary.
Okay, bye.